in terms of, I wasn't really thinking in terms of notifying Campbell, although I appreciate the answer. It's within the scope of my question. But what I was specifically wondering is, would it have been your pattern and practice as a prosecutor to make sure that the other prosecutor handling Philip Campbell also had this letter, since it at least purports to be an admission by a defendant?
There would not have been another prosecutor until such time as I was ordered to active duty. That's when it would have been transferred to Ed Sweeney.
So you were handling both cases. Now that I think about it, I think you said that yesterday. You were handling both cases.
Yes, sir.
All right. Go ahead.
Yes. So when you got these letters and read them, and this one refers to the only reason why B.A. put one is because Marcus knew he stayed down. I'm talking about putting mask on. Who was B.A.?
I don't think I knew who B.A. was until this issue arose 4 years ago or 3 years ago.
Yes.
I think that B.A. turned out to be whoever is he's the one that's got a life with no parole sentence. He was 17 at the time, so he couldn't get anything more. And I think that's the same guy as B.A.
Would that be B.A. Howard?
Yes,
James
sir. I
B.A.
think
Howard?
so. I think so, yes. I don't know where the B.A. That could have been a nickname.
Okay.
Well,
This letter is written as Phil Bone talked in those days, and it's pretty clear he is saying, hey, it was me.
Your Honor, I would object to the form of the question.
Well, you are stating a conclusion.
Yeah.
Perhaps reserve that for argument. You have not asked me, and you might have been able to, given the circumstances, to consider this witness hostile, allowing you to leave.
Well,
So I'm throwing you a hint, and I'm leaving it to you strategically to see if you wish to do that.
Your Honor, technically you're right. Dwight Howard and Dwight Warren.
Dwight Howard? Or?
Dwight Warren would be a hostile witness. He and I have talked on the phone.
We're buds.
He and I talked on the phone. I did not want to technically.
I understand. I get it. I get it.
A
All right.
hostile witness, okay? And I appreciate his testimony.
All right.
But when you looked at this, did you feel this was admission by Philip Campbell that he and James Howard, B.A. Howard, killed Marcus Boyd?
It may have been, and I certainly would have looked into that when it got time to prepare Philip Campbell's case, number one. It also says that Philip Campbell is bragging about doing the shooting in that first sentence. I don't know why you keep telling people we tried to kill Marcus. So that, to me, tells me that Lamar is telling people that he tried to kill Marcus, he and Philip.
You think you interpret this? You interpret this as saying Lamar is telling people that he killed?
Look, read that first sentence.
Well, let me read the whole thing. I don't know why you keep telling people we tried to kill Marcus. Went up there to pistol whip Marcus about talking shit to Puppy. When we ran out the gangway, B.A. tried to grab Marcus. They started wrestling for the gun, and that's why we had to shoot him. I don't know why Honky lied about us having on a mask. The only reason why B.A. put one on is because Marcus knew he stayed down the street, and he might tell what we would have did to him. Nobody didn't point no gun at that Honky after we shot Marcus when I ran back around the house. You think that's Lamar is telling people that he and who shot? He and Bone, he and Marcus, he and B.A.?
All right. The first sentence again says, I don't know why you, Lamar Johnson, are telling people that we tried to kill him.
Right.
So that's saying Phil Bone here is saying you, Lamar, are telling people that we meaning Lamar and Philip, The same.
I'm going to ask you a question. Do you not interpret that letter as we in the first line being clearly explained down through the full context of the letter as this Phil Bone person and B.A.? Because in context, you tell me. I mean, I'll decide later how I think it comes across in context, but I'm just trying to see, do you, as you read the entire letter, do you not see that that's what there is, or how do you see it? I guess that's the more appropriate question.
Absolutely.
How do you see
I
it?
see that as a nonsensical attempt on Philip Campbell's part to exonerate his buddy Lamar Johnson. Just because it's written does not make it true.
No, that's, I know that. Okay.
Jonathan, you have the next.
And this letter was in your possession, or I shouldn't assume, was this letter in your possession before the trial?
No, sir.
All right, so this came in your possession after the trial.
Yes, sir.
And how soon after the trial did this come into your possession?
Charlie, is to refresh my memory, that it was sometime in September.
Yes.
And I would agree with that. That I think is also indicated in the police report he was trying to find.
I think that's right, Your Honor. I think we talked about this yesterday. It came about between the conviction, which was July the 12th.
He said something I found very interesting. You said it was referenced in a police report?
Yes, sir. He found a police report. He gave it to me yesterday, and he can't find it today.
A police report that was written after the trial?
Yes, sir. When the search warrant was executed.
Oh, a search warrant that rose exclusively. I'm sorry, a police report that rose exclusively from the search warrant.
Yes, sir. Yes, sir. And that was after Lamar's verdict.
Okay, let's get that in context.
Okay.
So I remember what happened is after he was convicted on around July the 12th, 1995, there was a motion filed for a new trial. And in that motion for a new trial by Mr. Bruns, they referenced correspondence between Lamar and Campbell. And Mr. Warren learned about that.
So and nobody here can speak for Mr. Bruns, so this is probably a question that should be asked. But evidently, as of the filing of the motion for new trial, which I'm going to assume, I have to check the record, was filed within time.
I think so, unless...
As of that filing, the letter was known about.
I believe so, Your Honor. Mr. Bruns is going to be here. He's our next witness.
Make that inquiry, so
We will.
I don't have to do
Yes,
it.
I think it's somewhere between the conviction and when Dwight Warren issued an order to go over and get the letters, which I think was by September of that same year. That's when these letters were written back and forth. And I should say also that when Lamar got these letters, he wrote letters back to Campbell. We don't have those, obviously. They're gone. No copies were kept. But the only thing that Lamar kept was what he got from Campbell, which we're showing you now.
All right.
So the next, as part of these letters, another one says, Lamar, which we got up here, this is part of Exhibit 2. Lamar, so that's how you're going to play it? You're going to cross me and turn state on me? I don't give a N-word. I don't care if you didn't have anything to do with killing Marcus. You locked up for B.A. F you. I ain't doing S shit. I'll see you when you take the stand, N-word. And if I lose, I'll see you up there, and only one of us is coming back home alive. That all my life, N-word. You ain't no soldier. You're a snitch for the state, N-word. When we get to the pen, beware of the steel blade, ho. Does that indicate that Lamar was involved?
Does that indicate Lamar what?
Lamar, does that indicate to you that Mr. Campbell is saying Lamar was involved?
I'm sorry, you were interrupted on the last 3 or 4 words. What?
Does that indicate to you that Mr. Phil Campbell is saying Lamar was involved in the murder?
He's asking him to be a snitch. No, he's accusing him of being a snitch. How could he be a snitch unless he knew what was going on? That's one interpretation. The second thing is, because one co-defendant writes another, I am not going to put much credence or credibility in one statement from a co-defendant to another. I don't think I would be able to use it in court.
Well,
legitimately.
hold it now. This is after the trial. We're talking
Exactly.
about motion for new trial stuff.
It is, Judge, but it also has a possibility of being used as evidence in Philip Campbell's case.
But Campbell is confessing that he did it, right?
It doesn't say that specifically. You can read that into it, but yes. But that has nothing to do with the credibility of that statement vis-a-vis Lamar Johnson.
Even the line, "You locked up for VA," doesn't strike you as significant on the issue.
Significant as to look at, but not as to the truth of the matter. That would be blatant hearsay, and hearsay is something uttered for the truth of the matter asserted, and I can't vouch for the truth of that.
Well, you know, hearsay is also offered as direct proof of state of mind, direct proof of intent, direct proof of then existing scheme or plan. I can go through
Declaration
a long
against
list,
interest,
actually.
right?
But
I mean,
as to Philip, not as to Lamar. This is all a statement by a co-defendant who's yet to have a trial.
Well, I wasn't really talking
Lamar's
about Phillips.
case is
actually.
over.
Yeah, well, actually, Phillips' case isn't in front of me. Lamar's situation is.
I understand, Judge. And this is a statement to Lamar. That wouldn't come in trial. There's no way
All right.
that would be admitted.
so Your Honor, I found the part of the police report that we looked at yesterday. There's a lot in here. Talks about the execution of the warrant, talks about instruction to go over and film the actual search of the cell that we saw yesterday. Talks about Attorney Warren noted that he had instructed Detective Torretta that during the execution of the search warrant that only handwritten correspondence was to be seized, and that the detectives were to conduct a cursory inspection to determine what papers were to be seized. The detectives were not to read the papers in the entirety due to the fact that a judge was to study the written correspondence and determine its evidentiary value. Then it goes on, the cell was photographed, they seized the documents. Detective Torretta was the person who did it. They took him back to Jimmy Edwards, who was a judge at that time, Your Honor, who since retired. I know is now over at Lashley, but Jimmy apparently was involved in it, Judge Edwards. But anyway, this is, you want to look at that at all? And it does say that
Does it have an exhibit designation?
I forget what exhibit it was, Your Honor. We did introduce it yesterday, and I don't have it listed.
Your Honor, I can help with that. I took those pages actually out of one of the Attorney General's list of exhibits. It's from I believe it's their exhibit 43.
Say that again?
Their exhibit 43, I believe. I had to pull the pages kind of out of the middle.
It couldn't have been our exhibit 43,
'Cause
your letters.
I know you were using letter designations,
Give me
right?
a moment. I want to say it's double F, FF1. I don't believe that's one that I've given a specific designation, but it is within that.
So it may not have been introduced. Is that what you're telling me?
The state has not offered it, but I'm happy to mark it as a state exhibit and offer it as a copy of it here.
It's our,
All right.
my understanding, Your Honor, now it's exhibit.
Well, should I receive it as your exhibit or their exhibit? That's
it's
all I want to
our
know.
exhibit 44.
Oh, okay, exhibit 44, and I'm assuming, given the fact that you said that from the AG's office, you were willing to proffer it too, no objection to its admissibility?
No objection.
All right.
Okay.
And do I have 44 in your exhibit book, counsel, for relative?
Your Honor, you
Look,
have my copy.
looks like I go from 37 to 45.
You have my copy.
Any problem with me taking a courtesy copy from the AG's office? All right. I'm going to designate this by hand as Relator's 44, so I'll know how to look at it. Go ahead, Counselor.
So, Jonathan, would you bring the next one up, please?
Actually, I'm sorry. You're presenting on behalf of the circuit attorney, aren't you? I'm
Yes,
sorry.
Your Honor.
So that's CAO 44.
There's a fourth letter that we have and that was in the file. Let me read that. Lamar, I'm going to reel with you. I don't really know what I want to do because I want to help, but if I didn't, I would feel bad. I sit and think so I can see where you're coming from. You're right. BA didn't show us no love. I'm not his side. Snitching is something I cannot
Judge,
do.
may I step down so I can read that?
You most assuredly can.
I can give you, here, let me give you a copy.
All right. Thank you.
I'm not his side of snitching is something I cannot do. I'm just saying, we were in the game, and you know how the game goes. BA just got lucky and didn't get caught. I know what you're facing, and if I was in your shoes, I'd be scared too, but it was something I had to do. The reason I was tripping is because I thought you gave your PD the letter. Don't do that. That will F things up if I go through with it. I'm not turning my back on you, it's just you. Talk some big shit. And I was expecting you to stand on it. Tell me the truth. If I didn't help and went to court, would I be wrong? What would you do in my shoes? Tell me the truth. I don't want this to break us up. We was in the game. We know how the game goes. Straight up. You win or lose. In other words, as I read this, Mr. Warren, tell me the way you read it, is that Mr. Phil Campbell is writing Mr. Lamar saying, I'm sorry, but BA and I did this. But don't you tell the public defender for Mr. Campbell about any of this, because I haven't said anything.
I don't know where you came to that conclusion.
Okay?
I see this as trying to make peace with a friend of his because he thought that Lamar was snitching on him.
I need to make you both aware of something to which you may wish to lodge objections if you wish. Judges, like jurors, as fact finders, are allowed to bring in their personal experiences and backgrounds. You should know the way in which I grew up, reading that letter isn't as difficult for me as it might be for others. But I will take that letter. I will place upon it my experience and knowledge as to what the meanings of those words are. To be perfectly frank with you, the street language at that time wasn't too distant from the street language I grew up with, and I will be applying that. Unfortunately, it puts the both of you in a difficult place because you don't know how to necessarily deal with that. But it is what it is. I am who I am. This is the court we're in, and that's the letter that was written. So let's proceed.
And I appreciate that, Your Honor, and we have no objection. We can read this letter and apply our own common sense as to what it means.
Well, common sense may differ. The judge's background leads him to one conclusion based upon his common sense. My reading of that may be different from his, may be different from yours, and I do not see that as a truthful statement. Okay? Because I come here with 40 some odd years of experience in the courtroom on prosecution, and I know many, many, many times that one co-defendant will snitch on another, or another one will try and defend. So I do not see the truth necessarily of this statement.
You weren't around for the ultimate prosecution or the guilty plea by Phil Campbell, were you?
No, sir. I only read about it in the transcript of his plea of guilty.
And that case was handed over to Ed Sweeney, who was in the office after you left.
Yes.
Okay. Do you know what happened in the Phil Campbell case?
Yes, sir.
What happened?
Philip Campbell said that he and Lamar Johnson were the shooters.
Okay. And,
Under oath to, I think it was Judge Berger.
okay. And that was a typical guilty plea process where usually the prosecutor or who's ever there saying, here's what you're pleading guilty to. Do you agree with it?
No, sir, it was more emphatic than that. I think Judge Berger specifically asked him, did you and Lamar Johnson do the shooting? The transcript of it will speak for itself.
Yeah, I understand. We have the transcript. You weren't there at the time, right?
No, sir.
Okay.
Make sure the two of you know the issue, reference the specific pages for the court, right? Probably better isolate them and then attach them to your post-trial brief or present them to me directly during this hearing. Go ahead.
You were in the office in 2012, in the Circuit Attorney's office, right?
I'm not sure. There was a time, approximately 2010 or 2011, that I departed the office as a full-time prosecutor. I was appointed by D. Joyce Hayes as a special prosecutor in case something came up, but I never had a case during that time until I returned in, I believe it was 2015.
Okay, so were you aware that there were requests to the office by Midwest Innocence Project and others for any information or documents regarding payments to Mr. Elking prior to the trial of Mr. Lamar Johnson?
I was not aware of that until such time as 2018 or 19, when Project Innocence or somebody started a motion by Kim Gardner to set aside the verdict.
Okay.
That was the one that was ultimately ruled on by the Court of Appeals.
Okay, sir. During the preparation for the trial of Lamar Johnson, do you remember whether you received a notice from the defense and request of discovery of rebuttal of alibi?
Unless it was their typical one,
Yeah.
which
Yeah.
I would have honored.
Let me show you what has been marked as Exhibit 82.
What's that?
Exhibit 82.
Not 73? That was a special one? A different one, okay.
I don't think I have.
Okay.
I don't have these.
I'm not familiar with it, but I'm sure I received it.
So under the rule, if there's going to be an alibi presented, they have to notify you, right?
What's that?
Under the rule at that time, if the defense were going to present an alibi, they had to notify you, right?
Yes, sir.
And they did. And if you read this, they notified that it was going to be Erica Barrow, Anita Farrow, and Robert Williams as an alibi. Do you remember whether or not you provided any notice to the defense that you were going to have a rebuttal of an alibi defense?
No, I don't. The alibi itself was presented in the original police reports.
Okay. So I haven't found anything in the records where you wrote back to Mr. Bruns or filed something in the court saying we're going to have a rebuttal to this. Okay. Do you remember whether you did or not?
I do not.
Okay, sir. Do you remember at the trial there was evidence that Mr. Lamar Johnson was over at another apartment with his wife, with his girlfriend and little baby, and that he had left for about 5 or so minutes, came back to the apartment where everybody was, and that you presented Detective Joseph Nickerson to rebut that?
Yes, sir.
Right?
Excuse me for just a moment. Can you start two questions back? Can you start that for me? Pull that up for me later. Thank you. Go ahead, Counselor.
Detective Joe Nickerson got on the stand and said that he could drive from the apartment where Lamar was that evening over to the address where Marcus Boyd was shot in about 5 minutes.
Yes, sir. That was rebuttal to information I received during the trial itself. I did not have the time frame of what Miss, is it Barrow? I did not have the time frame where Erica Barrow said it was, you said 5 or 10 minutes? I didn't have that until the trial. Then I had Joe Nickerson make that trip. So I didn't, it was rebuttal.
You had Joe Nickerson make the trip after you found out it was going to be, there was going to be testimony?
No, sir. After the testimony occurred by Miss Barrow that it was 5 or 10 minutes. Up until that time, I had no idea that she was going to testify to that effect. This alibi suggested that, basically, that he was with her.
Yes.
Nothing about taking a trip for 5 or 10 minutes.
Right. Okay.
That was not part of the alibi. When it occurred during trial is when I had Joe Nickerson that night drive that route, and as you said, 5 to 10 minutes. During trial, she said it was 5 minutes, could have been 6, could have been 7, and denied that it could have been more. But you just said 5 to 10.
So let me understand if I...
What's that?
Let me understand what happened.
Hold, I have a question for you, because I'm looking at the June 26, 1995 notice of intent to proceed with alibi filed by the defense pursuant to rule, and they give you the specific witness list, including Erica Barrow, and an address. Did you not have an investigator interview that person upon receiving this notice?
No, sir. I don't
Can you
think I
remember
did.
why?
What was the date of the trial?
July 11 and 12, 1995.
July 11th.
Yeah.
This notice of alibi was given to me less than 2 weeks before the trial.
All right. Then,
I might not have, number one,
you
I
didn't
might-
go to the court and ask for a continuance, ask for a bench subpoena. Did you make any attempt at all, deposition, or did you just send people out there and say, look, you know, go see this person, see what they have to say?
No, sir. I expected her or them to testify as to an alibi.
So then, if I'm reading you correctly, you assumed the risk of what they would say by saying, I'll just deal with it as it comes during the trial.
Yes, sir. My experience has shown me that if you deal with defense witnesses too much, they will then glean where I was going and fashion their testimony to their advantage.
So
I didn't want to do that.
And I'm not saying it was a good or bad strategic decision, but it was a strategic decision.
Yes, sir.
And when you found yourself in a situation of, well, I have to get somebody to rebut what Ms. Barrow said, those were circumstances that came with the risk of your strategic decision.
I don't know. It could have been. I don't know what came as a result of my strategic decision. I did not know the time, or that she would say that Lamar was out doing a drug deal. I didn't know
because
that.
you hadn't talked to her before.
Correct.
Right. And so when she said it, you said, oh, I got to get somebody in here to attempt to rebut that. Is that where your head was at that moment?
No, not suddenly. When she said that, and Nickerson's still around, I had him do it.
Right. Okay. I got you. You can continue, Counselor.
Thank you, Your Honor. So if I understand what happened is Ms. Farrell got on the stand at trial and testified that she was with Lamar that evening in an apartment with others and Lamar. He had left for about 5 minutes but came back immediately. And she was the last witness, wasn't she, for the defense?
Number one, I don't know when she said that he was out doing a drug deal. I don't know if she said that at trial or later on in her affidavit, but she said that he was doing a drug deal. Yeah, you can't do a drug deal in 5 minutes. So, and he got into a car that was outside that apartment. That gives him the mobility to drive, like Joe Nicholson said, 5 minutes there and 5 minutes, do the crime, 5 minutes back. The fact that she says she was there that he was gone 5, 6, or 7 minutes, she didn't have a watch, and those are the facts that were presented to the jury.
So, after Erica Farrow testified, you asked Detective Joe Nickerson to get in the car and drive out to the place of the murder?
At the conclusion of the proceedings that day, yes. I mean, I don't see any...
So was the court recessed at that time, or Detective...
Oh, I think it was recessed for the day.
So he drove out there, came back, and told you, hey, I can do it in 5 minutes, right?
Yes, sir.
Okay.
And testified to that.
Okay. Have you done it?
Yes, sir.
You have done it. Can you do it in 5 minutes?
No, sir, it took me 6.
Took you 6. You know, we have videos. I don't know if anybody's going to introduce them. The state has a video that they put somebody in a car, drove out there and drove back, and it took them, I don't know, 16, 17 minutes.
Well, maybe they weren't in a hurry.
And we did one that took about 20-some minutes.
20 minutes?
Well, let's not get into to that.
Okay.
If you have a witness to quantify your we, then you can put that witness on at that appropriate time. Otherwise, that's not going to be considered by the court. It's technically speaking struck, to be honest with you.
That's fine, Your Honor.
20 minutes, you could walk it.
Mr. Warren, are you familiar with the scene of the crime? Did you actually go out at 9 o'clock at night on a dark night in October and see what it looks like?
No, sir.
Do you have any idea how dark it was that evening?
9 o'clock at night on what?
October 30?
I would say it's
Day
dark.
before Halloween?
I'd say it's pretty
Court
dark.
can take judicial notice that it would have to have been dark, full darkness.
Okay.
Go ahead.
Do you understand that there was really no lighting other than what was coming from the stairwell of the apartment?
That is my understanding.
Okay. And you know they all had masks on, right? Is that your understanding?
When you say they all, you mean
The
both?
two perpetrators had
Yes.
masks on and dark clothing.
And what?
And dark clothing.
Yes.
Does it seem reasonable to you that somebody who was there watching the two people shoot another person could actually make a positive identification of someone they didn't know?
Yes, sir. And I inquired from Mr. Elking that very fact. And I wanted to make sure that he was emphatic that he made a positive identification. If he had not, that case never would have been issued. But he was emphatic that he was positive.
And that's what
Okay, hold on. You told me yesterday that he's in the room to identify the lineup, doesn't make one, comes out and says, I was scared, while he's not looking at the four of them, says it was number 4. There was no re-line up, and that fit your definition at the time. And I'm not saying, people have different definitions. I'm just asking you, that fit your definition at the time of emphatic?
No, sir. I had to inquire from him more. Are you sure you have failed to identify somebody and now you're identifying? I want to know why. And he said, I was afraid. I want to know I'm not prosecuting somebody that doesn't deserve prosecution. And Elking was positive that the person he identified, I think he said he had a bad eye or something along that line, but I was left with the feeling that Elking was positive in his identification. And, I didn't just take the fact that he had viewed a lineup, failed to make an identification, then recanted that. I cross-examined him on how sure he was. And he was sure.
I was going to ask you this question, I think you answered it. I think you said, without the eyewitness identification, you would have never filed charges against Lamar Johnson.
Oh, absolutely not. I mean, I didn't, unless he'd had a confession, I didn't have any evidence.
Thank you.
You're welcome.
Start that, please.
I think we talked yesterday somewhat about letters that Mr. Mock wrote. I would like to sort of turn this around and talk about Mr. Mock now, if you don't mind.
Okay.
So, and I know that you exchanged letters with him, right?
What's that?
And you exchanged letters with him prior to and after trial.
I don't know that I exchanged letters with him. You were talking about communication, and I said that I wouldn't know where to phone him, but that he called me. I think that's what you're talking about. But I don't remember any exchange of letters other than from me to the Board of Parole and Probation and Parole.
I'm going to show you what has been marked Exhibit 183-1. This is a letter from Mr. Wallace, F.D. County, on 5/13/95.
You walked away. I couldn't hear you.
I'm sorry. This was a letter to Mr. Wallace Thumb, dated 5/13/95. Yeah, 183-1.
183, Counselor?
183-1.
183-1?
Yes. Mm-hmm.
So that's 183-1?
183-1. Yeah.
Thank you.
Yeah, sorry. Give me a copy. Take a time to look at that, and I ask you, do you know a Mr. Wallace?
No, sir.
It's a kind of a long letter, but
It is, and I'm only on halfway through.
Thank you. Do you know if there are only 2 copies in there?
Okay?
So, did you receive a copy of this letter?
Just now?
Just now, you didn't know about it before?
No, sir. Never seen it.
Who is Wallace Plum?
I have no idea.
Okay. He's talking about,
Remember, I'd object to asking Mr. Warren any further questions as to the contents of this letter. It's before the court, but he has never seen the letter before today.
Overruled.
Thank you, Your Honor.
That actually might be a point, that he had never seen the letter before today.
so, Mr. Warren, on page 2, he says, on the other end of the phone was Chief of Homicide Prosecution Dwight Warren. He told me what I needed to testify.
Incidentally, FUM here, you will note that it's has a dot after the F and the U and the M.
I noticed that, Your
That
Honor.
may be functional unit manager. That may be a correctional office.
Your Honor.
I think that's correct, Your Honor.
Yeah.
Subject to protective order.
Right.
We can get this out.
That's okay.
Thank you, Your Honor.
That's all right.
You were quoting something?
Yes, he says that, I asked him what I needed to testify in the trial. Out of prison would be a new start, I answered.
I'm sorry, where are you in this
I'm on
letter?
second page, first paragraph.
Okay.
And he says, at the end of the phone was Chief of Homicide Prosecution Dwight Warren. He asked me what I needed to testify in the trial. Out of prison would be a good start, I answered. His response was, who do I call? He said, I can't promise you anything, but I will call the governor if needed. I told him that I needed some time to think over. Not knowing what to do, I spoke to Lieutenant James, looks like Carr, in the
I think it's private.
I had known him his first day on the job at Algoa in 1988. I asked him what he would do because I trusted his judgment. He told me to testify. I asked God, prayed about it. I called them and tell them I would. They promised me everything. They promised me everything, something. The words are, they promised me everything. I testified after 3 long rides, handcuffed. They were convicted in first-degree murder. Do you remember any of that at all? Did Mr. Mock talk to you about that?
I had a conversation with him on the phone about what I could do for him.
Yeah.
He didn't ask anything about the governor. He asked about getting on parole. That resulted in a letter that I wrote. That's what I told him. That's what he testified to in court. As far as I said, I can't promise you that, and he said something about getting everything. I don't know what everything means. Mr. Mock had a different idea than what I do about everything. Everything would include, maybe $2 million to testify. I didn't promise him anything other than to write that letter. That's what I revealed to David Bruns. That's what I revealed to the jury, and that's what Mr. Mock testified to.
At the end, the last page of the letter before his signature, he says, you can verify everything I've said by calling Prosecutor Dwight Warren at 314-622-4941 or Detective Nickerson of Homicide at the St. Louis City Police Department. Is the 314-622-4941 your number?
No, sir. That's the main switchboard for the Circuit Attorney's Office.
For the Circuit Attorney's Office,
Yes,
where
sir.
you work?
Yes, sir.
Okay, sir. Next, I'm going to show you Exhibit 183-23. This is a chronological data sheet for William Mock. 183-23. Here, I got an extra copy.
Before questioning, do you, counsel for the Attorney General, do you dispute that this is in fact what it purports to be?
Your Honor, if I could just look at it for a second.
Certainly.
Affidavit of who? Oh, okay, that's it, okay. Okay, got it.
Your Honor, it appears that this is a Department of Corrections issue. The Office of the Attorney General has no objection to that being a part of the file, but we would not be admitting that anything, or agreeing that anything contained within an issue, but it is a true document, and no objection on that front, Your Honor.
All right. And I think I told you guys that I spent a number of years working in the department, so I should add, I've taken notice of what's at the bottom, which is how we designated forms and continued to do years after I left. You see it, MDOC, Missouri Department of Corrections, comma, P&P, that's probation and parole, meaning that the document is the same across the divisions in the department. So I want you to know I've taken a look at that and also taken that to account on the question of authenticity. I was trying to see if there was any substantive objections that either party had before I went any further. Seeing none, Exhibit 183-23 is again, if you may inquire, Counselor.
So, Mr. Warren, I'm gonna ask you whether, I got some questions about the 8-07-95 notation. It says inmate restriction notice 07-27-95 filed CORR to R. Pash from Circuit Attorney, City of St. Louis, Ray, inmate cooperated in a recent homicide prosecution, and Dwight A. Warren, Assistant Circuit Attorney, requesting override to C-2 to attend drug treatment program. Filed correspondence to Vicki Myers, DOC, from the Circuit Attorney, City of St. Louis, Ray, inmate agreed to be state witness. You did, I gather, make requests to the prison or to the parole board to help out Mr. Mott, right?
Yes, sir.
Okay. And who is R. Pash? Do you remember who he or she was?
Who is who?
R. Pash, P-A-S-H.
I don't know, but you only gave me page 2, not page 1 of this chronology. It may be contained in there. There is a reference to something that was filed on 7/27, and that does not appear on this because page 2 starts with an event that occurred on 7/26. So it may very well be in the first page.
But you don't know who Mrs. Pash is without reading the
I have
first
no
page?
idea.
Okay, so how about what requesting override to C-2? What does that mean?
I have no idea what C2 means, but it says that it was filed to Vicki Myers, and that's the addressee of the letter that I wrote.
C2 is Class 2,
99.
lowest to security level.
Oh, okay. Well, I didn't know that.
You would not have.
We have a person here who was counsel to the Department of Corrections.
What's that? Oh,
Nothing, just a comment. So, do you recall, though, requesting that Mr. Mock be entered into a drug treatment program?
do I know that? No, I don't know that.
Do you know that you requested that?
I don't.
You don't remember that?
I never had that information. He wanted a complete discharge. And I wrote in the last paragraph on your exhibit number 99 that I understand that Mr. Mock has served enough time on his sentence to be eligible for parole.
Okay, I
Nothing about
have to ask this question. Because the bureaucracy of the department is not unfamiliar to this court. written in here, in a recent homicide prosecution in the White A. Warren, Assistant Circuit Attorney, requesting an override to C2 to attend drug treatment program. An override to C2 takes a person down enough in security level so they can participate in drug treatment program. Am I to assume that the drafter of this entry lied in the public record?
No, I didn't.
So then evidently, you made the request.
I didn't make a request for C2, which is a status I have no idea. This is a letter that I wrote.
All
Now,
right,
if they have to reduce him to a C2
I get
level,
your position.
that's up to them.
I get your position.
Listen to Brooke. Well, let's, after the judge asked you that, I'm going to show you Exhibit 18320. Mr. Warren, this is a letter from you, from Miss Rhonda Pash, dated July 17, 1995. And Your Honor, I'm told this is in your book.
Wow, what's the number on that?
183-20. And let me read it because it says, this is from you, signed by you, dated July 17, 1995.
Oh, let's not make any assumptions. Ask him if he can identify
Yeah,
that
sure.
that's his signature.
Sure. Can you identify this as your signature and that you sent this letter?
I don't ever remember seeing this.
That's your letter?
The
Is that
question
my,
was, is that your signature?
is that my signature? It looks similar to my signature. It may very well be my signature, but I cannot say that. That Warren W does not look like mine. I don't know how this originated. It may have been authored by me, but I have absolutely no recollection of it.
Well, let's look at it. Dear Mrs. Pash, I am Chief of the Homicide Section for the St. Louis Circuit Attorney's Office and am writing this letter to you on behalf of Mr. Fox. At the time you were Chief of the Homicide Section of the St. Louis Circuit Attorney's Office.
I can't find it under my 183. I'm sorry. I hate to keep bugging you guys for specific copies, but all right, thank you. 18320.
So were you Chief of the Homicide Section in July of 1995 of the St. Louis Circuit Attorney's Office?
Yes, sir. That was after the trial, correct?
And then you say, Mr. Mott cooperated with the state of Missouri in a recent homicide prosecution and was very helpful. Is that true?
What's that?
Did
No,
that
I didn't
happen?
hear the question.
Did that happen?
That he cooperated? Yes.
And he was yeah. And then you say, if it is at all possible, I would appreciate if you would consider an override to level 2 for him in order that he may he attend a drug treatment program.
That's what it says.
You don't remember writing that?
I do not.
You
I'm
do
not
not.
saying, what?
Do you deny writing it?
No. If you ask me if I remembered it, no, I don't.
Next, I'm going to show you Exhibit 158. Your Honor, I believe this is in your book.
158. Give me a second. See, I'm sorry. My numbers go from 123. Well, hold on. I could be wrong. Give me a second. 124. Yeah, there's a big open space here. I'm sorry, I don't have it.
Judge, there's a second binder that's smaller. It says mock on the front. You have a second binder that's quite a bit thick. I believe that's
guys have given me so many binders of people. Okay.
This is a letter.
What was that number again, Counselor?
Pardon?
What was that number again?
158, Your Honor.
All right.
It's dated 1-21-95. It's Dear Dwight, signed by Phil. Hey, you knew William Phil Mock.
Can you give me a moment? I'm only
sorry, yeah.
halfway through the letter.
Sure, I'm sorry.
Okay, I've read it.
So did you receive this letter from Mr. Mock?
I do not recall ever receiving any letter from him.
Pardon?
No, I don't recall
You
it
don't
ever.
recall receiving any letters from Mr. Mock?
No, sir, I don't.
So, did you refer to him as Phil or William or Bill
When?
when you were meeting with him, talking with him?
I talked to him on the phone, and I talked to him at the deposition, and I don't remember. Why would I call him Phil?
Because his name was William Philip Mock.
Well, see, that's a revelation to me. I would not probably have been so familiar as to even call him Bill unless he told me to. Mr. Mock would probably be the way I would talk to him. Probably.
Stop. As he told you to?
Hey, can I call you so-and-so? Sure. That way. Can Charlie call me Dwight? Yes. Can I call him Charlie? Yes.
Gotcha.
Because he said so.
I got you.
I did tell him he could call me Charlie, Your Honor.
Sir?
I said I did tell him he could call me Charlie.
He told me.
Next, I'm going to give you Exhibit 159.
Hold on. You said 50. I may have 59. Let's check to see if I have it before we put you through habit. Yeah, I do have 159. So you hold on to your copy.
This is another letter dated 1/27/95. Says, Dear Dwight, it's signed by Phil Mock. At the end he says, hey, I'd take Pittsburgh at 7 for a, looks like Packers, but I'm not sure. Anyway, I'll ask you to look at that, and I'll ask you whether you received this letter.
No, sir, I never did.
You did not.
No, sir. Because I wasn't with the office at that time.
in 12795?
96.
I'm looking at this, looks like 95 to me, but you think it's 96?
Well, I think him being transferred would suggest that it was after the trial. And I thought this was after the trial.
Is this 314-526-6436 number the circuit attorney's office or your direct number?
I don't. I think he's referring to somebody else that's got that number.
Okay.
Well, you said you weren't around at the time. Who did you assign your case file to in your